Thanks for joining us. Today is something pretty special at CITP. We talk a lot about government at CITP, and we think a lot about government. After all, much of the interaction of technology and society is moderated by government. But today we get to learn directly from someone who's serving at a high level in government. And that's not an opportunity that comes up too often. So I hope you'll join me in making the most of it. We're very fortunate to have Josh Goldfoot with us. Josh is a Principal Deputy Chief of the Computer Crime and Intellectual Property Section, or CCIPS, in the Department of Justice Criminal Division. Josh helps supervise a group of about 40 attorneys who investigate and prosecute computer crimes and criminal intellectual property offenses. CCIPS also plays a role in policy matters related to computer crime and intellectual property. Josh has been at DOJ since 2005, where he's worked on prosecuting computer intrusions and wiretap offenses, worked on electronic evidence and online investigations, among many other areas that will be of tremendous interest to the CITP audience. In 2013, he took a brief diversion from CCIPS to serve as the Deputy Chief for Cyber Policy in DOJ's National Security Division. So he also has deep expertise in national security matters. And then Josh came back to CCIPS in 2016. He has an extremely distinguished career at DOJ, winning a number of awards, including the Attorney General's John Marshall Award, which is the highest honor the Department of Justice gives to attorneys. He's trained hundreds of assistant US attorneys and other DOJ attorneys and other attorneys working in law enforcement in matters related to electronic evidence and online investigations, computer intrusions, again, many areas of tremendous interest to the CITP audience. One of the things I admire most about Josh is, in addition to being an outstanding career prosecutor, he also engages quite deeply with the academic community. He's in fact authored 5 law review articles, and from time to time, if you're fortunate, you can catch him at an academic conference. That's extremely uncommon in the government, and especially uncommon at such a senior level in the government. And it's something I certainly appreciate, and I've benefited from his input in my own academic work. Let me close by noting that regrettably, Josh went to Yale, but we forgive him for it. I got his law degree from UVA. He's been working in technology law since 1999, including a career in Silicon Valley before joining DOJ. Let me stop there. Needless to say, we're very fortunate to have Josh, and I'm very much looking forward to today's session.
Jonathan, let me start by thanking you for the kind invitation to speak and for that great introduction. You've actually made me feel a bit self-conscious now when you emphasize that it is rare for people at senior levels to engage with academia. Now I'm a bit nervous and wonder if I'm been making a mistake all along. But anyway, I've been a lawyer for about 20 years. I've spent the last 15 of those working in the Department of Justice. As you mentioned, today I'm one of the managers in the Computer Crime and Intellectual Property section of the Department of Justice, abbreviated CCIPS. We have several jobs in CCIPS, but one of them is implementing the department's national strategies in combating computer crime, by which I mean we prosecute hackers. What I want to do today is share with you some of the cases we've seen, some trends, and maybe talk about a few of the conclusions we can draw from those. So let me start by telling you about one of our prosecutions. The case I'm talking about is United States versus Ryan Lynn. And right away, I want to give full credit to the prosecutors who worked on this case. One of them is named Mona Sedke. The other is named Amy Burkhart. Mona works in my section, but beyond that bureaucratic fact, I cannot take credit for this work. I just talk about it. So in April of 2016, Ryan Lynn became housemates with 2 women in Watertown, Massachusetts. One of the women, who we are going to call Jane Doe, owned a MacBook. She had a document on there that had all of her passwords to her online accounts. Ryan Lynn got a hold of that MacBook and got a hold of that document, and he accessed all of Jane's accounts. He got into both her Google and iCloud accounts. He also looked through her laptop itself. And from all this, he got a ton of private personal information. She had been keeping a diary with her computer, and he took it. He took her contact list too. He read her email. He got photos she had taken of herself in intimate situations. He got sensitive details about her medical, psychological, and sexual history, including the discovery that she had recently had an abortion. Mr. Lin used this stolen information to fuel a campaign of harassment against Jane. It would last more than a year. Ryan Lin sent Jane's diary entries, intimate photos, and videos to people in Jane's address book. In fact, he sent it to hundreds of people, eventually reaching almost everyone she knew. The pictures went to her boss, her coworkers, her parents, and grandparents. When Mr. Lin sent the messages, he of course wouldn't use his real name. He'd make up fake accounts, or in some cases, make it seem like Jane or her parents were the ones sending the material. Later on, Mr. Lin upped the pressure. Using the information he had stolen, Mr. Lin posed online as Jane Doe. He created online profiles seeking to have men go to Jane Doe's home for violent sexual encounters. Many men did show up, or they called her or her family. Mr. Lin had provided full contact information in the profile and threatened to rape or kill her. Thus, Mr. Lin's theft of Jane Doe's information not only tormented her, alienated her from her friends and family, made her quit her job and retreat from public life, but it also put her in real-world physical danger. Putting her real name and photos on those websites made her a target of physical and sexual assault. The story of Mr. Lin's campaign of harassment does not end there. Unfortunately, I could go on and describe other ways that he used the information he stole from her. But I think I've described enough now to illustrate an important point. We eventually caught Mr. Lin. Jane Doe showed extraordinary courage and helped our investigation. With her help, and thanks to the extraordinary work done by local Massachusetts police, by state and federal prosecutors, and by several computer forensic analysts, we built a strong case against Mr. Lin, and Mr. Lin ultimately pled guilty and was sentenced to 17 years in prison. Among the many criminal offenses Mr. Lin pled guilty to was one that arguably kicked it all off: his illegal access of her computer and online accounts. That was a violation of the Computer Fraud and Abuse Act, the chief statute my office uses to prosecute hackers. We call it the CFAA for short. The concept of privacy has many definitions and meanings, but when it comes to information, privacy is often defined in terms of the ability to have control over one's personal information. The reason why Mr. Lin's original crime of accessing Jane's online accounts and computer proved so devastating is that he took control over the ability to keep her information private. Using that information, he could turn her personal secrets against her, psychologically harass her, penetrate her network of family and friends, and impersonate her. This is an effective illustration of how important privacy can be. And it is also an effective illustration of how important it is that Americans can protect their privacy by controlling who may take information from their computers. It is that interest in keeping one's computers under one's own control that the CFA is meant to protect. The CFAA is an online privacy statute. All right, let me give you a second example of some of our work. There are computers across this country that have been hacked and are under the control of criminals. These are ordinary personal computers used by small businesses, sometimes large businesses, homes, and students. The owners of these computers aren't aware that they are under someone else's control. They don't give any outward indication of that, but running on the computer is the criminal's software. It can read any file, it can monitor keystrokes to steal passwords, it can scan its local network to infect other nearby computers. By some estimates, there are hundreds of millions of these computers worldwide. They are called bots, and criminals join bots into networks called botnets. Botnets are problems for everyone. They are used to attack other people's computers and to conceal the true sources of illegal conduct. How do these infections occur? Well, this part probably a lot of you know, but it's worth repeating. Criminals take advantage of software vulnerabilities. Software vulnerabilities are flaws in web browsers, office productivity software, and sometimes even in operating systems themselves. These flaws can then be exploited to give criminals the ability to run their own software on the underlying computers. These exploits are delivered to computers through web pages in the case of browsers, through documents attached to emails in the case of Office software, or even in rare cases, simply by a computer with a vulnerable operating system being connected to the internet. So several years ago, a series of small businesses found that their bank accounts were being wiped out. Someone was logging into their bank accounts over the bank's web interface and initiating an ACH transfer to outside accounts. ACH is the type of transfer banks use often for payroll or for large payments to other businesses. Now, banks have security precautions to protect against unauthorized people making those kinds of ACH transfers of funds. Notably, they make small business customers do something unusual for banks. They make them use two-factor authentication. So at the time, what that meant is that in addition to logging in with your password, the small business would receive a 6-digit code sent to their cell phone by SMS, and they would type that in too. The problem is that these victims were, without knowing it, using computers that weren't actually under their control. Now, sure, they were using computers that they owned, but a criminal gang had installed on those computers software that collected their passwords as they typed them in, collected their two-factor authentication codes as they typed those in, then used all that information to allow the criminals to log in as them instead. So as charged in indictments in Nebraska and in the Western District of Pennsylvania, defendants used these networks to transfer tens of millions of dollars. I should add, this is an indictment only, not a conviction. The defendants are presumed innocent until proven guilty. Now you might ask, who is doing this to us and how are they managing to do it? I will refrain from generalizing about our defendants. Some are very talented, while others are just following instructions that anyone can find online. But overwhelmingly, when computer crime is done for profit, it is being done by conspiracies. Economists talk about how economies involve specialization. Different economic actors learn to specialize in small parts of the overall economic effort. The same thing has happened with online crime. So consider the bank credential scheme I just described, and consider how much work is required to pull something like that off. To start, someone had to write the code that runs on victims' computers. You also, by the way, need a separate piece of code just to get it onto people's computers. Someone had to corrupt a corrupt PDF file, for example, that gains root access and then downloads the code that takes over the system. Someone then has to test all this software to make sure that antivirus software won't catch it. Then someone has to spam or spearfish these emails, and that's no small task because no reputable hosting provider will let you send spam, and most don't let you send any type of SMTP traffic at all. So you need basically an unrespectable partner to help you send the spam, or possibly someone else with a botnet. After the infection, someone needs to monitor the communications from the infected machines as the machines dutifully send to their new controllers the passwords and authentication codes as they're typed in. And someone else has to proxy through the victim to the bank and make the transfer. But who do they send the money to? They obviously don't send the money to their own bank accounts. For one thing, that would make life too easy for people like me. For another, you can't do an ACH transfer of funds from a bank inside the United States to a bank outside the United States. So instead, they transfer the money to a bank account owned by a money mule. So mules are Americans with American bank accounts. Mules receive the funds and then wire them overseas. Question, where do mules come from? The answer is someone recruits them. Why are mules doing this? Some mules know they're moving stolen money. Others are just being fooled, recruited from job sites to believe they're playing some financial management role for an international company. So practically every job I just described can be done by a different actor. And that's exactly what you see in today's online crime, specialization. There are people who specialize in coding and virus checking and sending spam and recruiting mules and leasing out so-called bulletproof hosting that won't cooperate with law enforcement and selling the use of a botnet and so on. The criminal underground also helps criminals profit from the information they steal. It is one thing and one skill set to obtain 1 million credit card numbers. It's quite another thing and quite another skill set to make money from them. But in the criminal underground, it is possible to find criminals who will buy the stolen information from you and do the work, and also, by the way, take the risk of exploiting all the stolen information themselves. So it was out of this landscape of crime that ransomware arose. So criminals have discovered that quietly sitting on a victim's computer and siphoning off sensitive data or processor cycles is not necessarily as profitable as ransom can be. And so the criminals use their power over the computers to encrypt their hard drives. Often they will have already spread to as many other computers on the same local area network as they can, so that they can take out entire enterprises at once. A ransom demand is made, usually by putting a cryptocurrency wallet address on the screen, but also sometimes by making the victim go to a dark website to make payment. Sometimes the ransom is accompanied by a threat to release sensitive client data that the criminal stole, which is like an extra incentive there. So I cringe a little bit whenever someone talks about ransomware as though it is a new threat. Ransomware is just another escalation in the abuse of victims' computers. All that ransomware actors have done is walk a few more steps down the criminal path that had already been blazed for them by more than a decade of crimes committed by conspiracies formed in an underground economy. We had already been living with the terrifying fact that so many Americans were sitting on top of computers that were secretly controlled by criminals. Ransomware is just a new and particularly visible and awful way for the criminals to exploit that access. That ransomware is so visible has made many more people than before turn their attention to the problem of computer crime, and to the extent to which so many American enterprises have been completely compromised by criminal actors. Ransomware has taught, in that way, the public about the danger that specialists in computer crime have been warning about for more than 10 years. So the damage that online crime has done to enterprises is hard to convey effectively. Businesses have had to close. People have been laid off. During this COVID-19 pandemic, we have seen hospitals attacked with ransomware. By the way, did you know that some medical devices in hospitals contain small computers that run on old, unpatched versions of Windows? We have seen municipal governments hit, not just with ransomware, but also with bank credential stealing malware, emptying large portions of their bank accounts. Even charities get hit. One Justice Department indictment describes an attack that targeted a convent of Franciscan nuns. So take all these victims together, along with Jane Doe, whom I described earlier. There is a lesson to be learned from all of them. Their plight points to the need for criminal enforcement of laws like the Computer Fraud and Abuse Act, vindicating victims' rights to be the ones in control of their own computers. There is a sense by some that criminal computer intrusion is a problem that can be solved entirely outside the criminal justice system by making computer intrusions technologically impossible to commit at all. Systems should be patched, vulnerable enterprise applications should be rewritten, passwords should be replaced with hardware authentication tokens, employees should be tightly restricted by access controls and their behavior monitored by artificial intelligence. You've heard all this before. For example, often when I speak about these criminal acts, criminal cases to an audience of information security professionals, I'll get several interested questions about the underlying hack or intrusion itself. People want to know how it happened so that they can judge whether it might happen to them too. That is good. Okay? It's a smart security practice. We should all analyze threats so that we know how to defend against them. But sometimes I detect a little bit more. A knowing nod and shake of the head, as if to say, those silly, neglectful victims, if they knew what I do, they wouldn't have gotten hit. So bear in mind, there's a grain of truth there. In retrospect, we can almost always see how an attack was preventable. The vast majority of computer intrusions aren't done through exotic 0 days, but are accomplished by attackers exploiting known problems, often by exploiting software vulnerabilities that we've known about for a long time, but that victims, for whatever reason, did not patch. The Department of Homeland Security periodically publishes a fascinating report that lists the most frequently exploited software vulnerabilities that DHS sees being used to attack critical infrastructure companies. Often security patches had been available for those vulnerabilities for more than a year. Meaning, if the companies had allowed their computers to download a small piece of code that is made available free of charge, they could have saved themselves from these terrible attacks. And I repeat, these are critical infrastructure companies that DHS is talking about. They're the type of victim that we would hope are more attuned to computer security than a non-technical housemate in Waterford, Massachusetts, or a county government in Kentucky, or a convent of Franciscan nuns. Victim blaming is a problem throughout criminal law, but it is especially cruel when it comes to victims of online crime. Yes, those of us who have taken the time to learn about information security know not to reuse passwords or to store them unencrypted, know to use two-factor authentication, and know to install software security patches as soon as they come out. Yes, but all of that takes knowledge and often a little bit of money. This is the role of criminal law and network security. It's possible to believe both that our country has a lot of work to do in making computer intrusions more difficult or impossible, but also possible to believe at the same time that realistically people and businesses have understandable difficulties securing their computers, their online lives, and their privacy. Criminal law fills in that gap. The gap between, on the one hand, computer owners' desire to protect their computers from intrusion, and on the other hand, the reality that securing computers is difficult work that many won't accomplish. The law in general says that people who own computers ought to be in charge of how those computers are used and in charge of when and how information is taken from them, and ought to be also the ones who decide who else may use them. To simplify things only slightly, the criminal law protects that interest. And it protects that interest even when victims make mistakes or underinvest in their own security. After all, we don't shame people who get mugged for not carrying weapons, and we don't say that a jewelry store owner who forgot to turn on the burglar alarm one night deserved to be robbed. So finally, I want to talk a bit about the people who work to find online crime and prosecute it. Your professor, Jonathan, told me that his students love hearing about government bureaucracy. So here we go. So first, the boring part, the lawyers. As I mentioned, I help manage the computer crime and intellectual property section. We are in Washington, D.C., part of the Justice Department's criminal division. About 70 people work at CCIPS. 50 of those people are attorneys, and 28 of those attorneys are line-level prosecutors who work in computer crime. That makes us the single largest unit within the Department of Justice to be focused on computer crime. But we are not the only prosecutors in the Department of Justice who work on computer crime. Criminal prosecutions in the Department of Justice is decentralized to a great degree. Most criminal prosecutions that are brought by the Department of Justice, in fact, are brought by United States attorneys' offices. So there are 93 United States attorneys spread across the United States and its territories, each with their own district. United States attorneys are each nominated by the president and confirmed by the Senate. The prosecutors who work in those offices are called assistant United States attorneys, or AUSAs. So at CCIPS, what we've done is we've worked to build a network of AUSAs who get trained and have expertise in online investigations, in computer crime, and intellectual property crime. This is called the CHIP network, which is an acronym for Computer Hacking and Intellectual Property Specialist. Okay, next, the investigators. So for the most part, the cases we prosecute come from two investigative agencies, the FBI and the Secret Service. The FBI is part of the Department of Justice. The Secret Service is part of DHS. Most investigations are done by the FBI. It's the larger of the two agencies. In computer crime cases, it's very common for agents to work closely with prosecutors from the beginning. Many investigative steps require a lawyer's help, require us going into court, or require us to get a subpoena from a grand jury, for example. So we tend to be involved early, and we need to understand the case at the earliest stages. But I want to mention a third group that is also super important in investigation, and that group is private computer security researchers. All of us in the government who work on computer crime benefit to a great degree from the work of private individuals who use their talent to study what criminals are doing and what tradecraft they use. We have seen private computer security researchers discover vulnerabilities and responsibly disclose that information in a way that gets the problems fixed. Many security researchers have also been allies in law enforcement efforts to dismantle criminal threats. For example, assistance with malware analysis and mitigation techniques has helped law enforcement conduct operations against various criminals, including through botnet takedowns. So at CCIPS, we have a dedicated unit, the cybersecurity unit, that regularly reaches out to security researchers. We go to their conferences, we sometimes get invited to their panels. We listen to their concerns, and we know that many of them receive legal threats from the private companies whose products they research. In many cases, those legal threats are baseless, but they are, of course, still quite concerning to those that receive them. I want to emphasize the legal threats they are experiencing aren't coming from prosecutors. A 2017 report from the Center for Democracy and Technology on legal challenges faced by security researchers found that criminal prosecution of researchers was, and I quote, extremely rare. I think we would actually place it lower than extremely rare. When security researchers are prosecuted criminally, it is because, separate from their research, they have also been conducting outright crimes. So this is what we're doing about the problem that computer security researchers face. When possible, we advocate for security researchers. We invite them to our CHIP training sessions so that the prosecutors most likely to encounter them have a better understanding of what they do and why. In 2018, we wrote a letter to the Copyright Office supporting an exemption to the Digital Millennium Copyright Act that allowed researchers to conduct vulnerability research on consumer products, including Internet of Things devices. And this year in February, we published a paper. The title of the paper is Legal Considerations When Gathering Online Cyber Threat Intelligence and Purchasing Data from Illicit Sources. And that paper helps security researchers navigate legal issues that arise when they conduct online intelligence gathering activities. So to conclude, here are the lessons I'd like you to draw from this. A great number of people today describe themselves as working in a field called cybersecurity. And by cybersecurity, they generally mean helping enterprises protect themselves from computer intrusions. The lesson I'd like to leave you with is this. Jane Doe and victims like her need cybersecurity too. Technological defenses do exist to help them, but for now, given the enormous odds that victims are up against, it's unrealistic to expect that every possible victim will reasonably be able to take advantage of those defenses. Criminal law can offer something to them. Vindication, possibly, if we convict someone, but more importantly, a deterrent. Criminal law can also be a powerful tool to disrupt the criminal underground economy I mentioned, both through prosecutions of key players and through online and undercover operations targeted at criminal organizations. That essentially is the work that I'm seeing being done in the Department of Justice today, and it's been my pleasure to speak to you about it.
Thanks, Josh. That was a wonderful overview of CCIPS and the work you've been doing. And I hope folks got that Josh is, in addition to being a very sophisticated attorney, also rather sophisticated about technical matters. I think we, in computer science, sometimes enjoy taking shots at the legal profession. And one of the things that distinguishes CCIPS is the extent of technical sophistication in their work. Okay, so here's the game plan for the Q&A. We're going to use Zoom's built-in Q&A feature. My hope is that we'll queue up some questions. I'll moderate for Josh. While we build up the queue, I want to go ahead and ask the first question, and that is, Josh, how do you think about the policy role of CCIPS in comparison to the prosecutorial role? You touched on some policy matters, the guidance you've put out that's valuable for security researchers, commenting on a rulemaking process by another component of the government. CCIPS participated in the Attorney General's Cyber Digital Task Force, which was a major Trump administration initiative to think about federal cybersecurity policy. So how do you think about CCIPS' policymaking role?
So all of us at CCIPS are career Justice Department employees. A lot of us worked before this administration, plan to work after it. That means we are not hired because someone cares about what we think about in terms of political matter or anything else. There's political leadership in the department, Attorney General, Deputy Attorney General, people underneath them. And they're entitled to reach out to any part of the Department of Justice for expertise and guidance on how to form their own policy views. And so that's true not only with computer crime, but really any type of work. If they have a difficult antitrust issue, they're going to reach out for advice to career people in the antitrust division so they can get advice that way. I think it's a similar dynamic here. When issues directly involving computer crime or other high technology things occur, the policy offices in the department will reach out to us or to other people who might have expertise and ask for advice. Maybe they don't, grasp all the facts. It's always valuable to just hear from people who are doing this from a living, how that comes. So I think that's part of it. I think also, we do see as a mission, I think I would put, frankly, what we've been doing with the cybersecurity unit in a slightly different category, because that's not so much dealing with legislation as helping to communicate with the public about the fact that we're here and what we're doing and how we're helping them. Criminal law, criminal justice doesn't work unless you have the people on your side, right? We need the cooperation of the people we're trying to protect. We need to hear from them and understand their issues. And so that type of outreach is extremely important for that as well. And yeah, when the Copyright Office is holding a proceeding, wanting to know our input for that, we'll offer that freely as part of that as well.
So I would note that in my service on the Hill, I had the opportunity to engage with CCIPS among other components of DOJ. And one of the things I really appreciated was the extent of nonpartisan expertise that was available when legislators requested it. The euphemism for those who haven't been on the Hill that you may encounter in future is technical assistance, which sounds like a computer science thing, but actually in this context, means reaching out to a component of the US government for their expertise in a particular area. Okay, let's get to the Q&A. Let me start with an extremely difficult question for you, Josh. Could you please give the acronym CHIP again? This is a question from Heather Mitchell.
Computer hacking and intellectual property. And then it's also, some people put specialist after that, some people put prosecutor, but that breaks the acronym. So we leave that part unsaid.
All right. Next question from Shannon Coney. Let's see if I can get this right. I'll be able to have Shannon ask it himself. Shannon, are you able to?
Can you hear me? Great. My question is that the promise of prosecutorial discretion feels pretty weak for some of us actually working in the field, especially given recent political turbulence with regards to prosecutions. Are there changes to the CFAA that you think would help balance the equities in protecting Jane Doe, but also giving researchers slightly more assurance and making us feel that we have to rely less on the grace of US prosecutors?
Well, preliminary, I would say that criminal law shouldn't work through grace. And I don't think we're asking anyone to be assured because don't worry, we would never prosecute those cases. I affirmatively don't believe that most of the conduct I've heard security researchers be worried about or being threatened about, I affirmatively don't believe that that is a violation of the statute as it's currently written. Giving, for example, I know that there have been cases where security researchers have obtained voting machines, examined them, found flaws in them, want to publish them. And then the people who make those voting machines threaten to sue them under the CFAA. To me, as a lawyer who works with the CFAA a great bit, I don't get it. I don't understand that claim. To me, it sounds like something that ought to be thrown out of court. I see the problem that security researchers are facing is that they are often going up against powerful, well-resourced companies who are able to hire lawyers who can write letters in an effort to try to intimidate and scare and block them out of that. I submit that's a different problem than just the CFAA. If we were to snap our fingers and the CFAA went away tomorrow and lawyers couldn't cite it anymore, those lawyers are still going to be able to write letters. They're going to put cybersecurity researchers concerned that they're going to be sued, right? They'll just cite different statutes or they'll come up with different legal theories. So I don't have myself personally views about whether or how to change the CFAA. I do want to hear from people who are in that line of work to tell me, what are you seeing? What are you seeing? I hope that I haven't heard from any so far saying that like I've actually been charged by the government or prosecuted because of my security research. That is just not happening currently.
Josh, maybe this is a natural moment for you if you could briefly explain the Van Buren case before the Supreme Court right now. Of course, the Solicitor General handles these matters at the Supreme Court, but CCIPS has been engaged with that issue in the lower courts. I think it'd be helpful for the audience just to understand what the issue is. I understand that we can't go too far down that rabbit hole.
Yeah, I really have to give you a pass because that is going to be argued in the Supreme Court next week. I'm not arguing it, no surprise there. My colleagues in Solicitor General's office are, and I would hesitate to even describe what the case is about or what, lest I accidentally make a legal argument that I shouldn't be making. But very generally, it is it's in front of the Supreme Court right now, and it deals with an interpretation of the Computer Fraud and Abuse Act, and specifically whether it allows us to prosecute people who work inside companies or enterprises and abuse the authorization they've been given to use that disclose that information to others that everyone agrees they ought not to do.
All right, so folks, if you're into the CFAA, this is a very important case to watch, and you have just seen an example of how Josh is really good at his job. Okay, let's move on. Next question from, and I apologize if I get the pronunciation wrong, Esin Tureci. Let's see here. I'm again going to try to unmute, and I apologize if I don't get this right, but I think I figured out how to do it.
Hello.
Hello.
My question is about the CFAA law, where at the beginning you said that CFAA prohibits unauthorized access to a computer, but you didn't necessarily say that that has to be followed by a subsequent harm to the owner of the computer or owner of the data. So is the subsequent harm necessary for the law to be considered broken? Or for example, would the person who gains unauthorized access benefit from this data but not harm the owner and still break the law?
Okay, it's an excellent question. So the CFA actually defines, depending on how you count it, 7 crimes. I won't give you all 7 of them now because Jonathan will jump through the screen and grab my throat. But I would say the ones that we use most often, the first is called A2. That prohibits accessing a computer without authorization and obtaining information from that computer. Okay, so that basically, if you think about the IT interest in the confidentiality of data, that's pulling stuff off someone's computer, downloading their files, and so on. Then there's A5 is probably the second most used one. A5 prohibits you from sending code or command to a computer that causes damage to that computer. Damage is defined quite broadly. It doesn't mean that you're reformatting the hard drive or reducing it to a smoking hulk. Any modification to that computer or its configuration that the owner didn't want is damage. So for example, installing malicious software on it is damage. That has to be followed up. And I'd say there is a third that's used a lot less frequently, which is accessing a computer without authorization and using that access to further some type of fraud, which is a deception on others. So an example of that would be hacking into a university's computer and changing your grade, right? You're not so much that you're stealing information or anything else, but you're making a modification, and that's part of a larger scheme that's going to be used to deprive someone of money. Those are the big 3. There are a few others. There's one that deals specifically with classified information. There's one that's rather obscure, that sort of deals just with the trafficking and passwords. But that is most of it. But no, the main answer to your question is, it isn't just the access alone that does it. There needs to be additional conduct after that for it to be a crime.
So let me include a shameless self-plug here. If you're interested in the various offenses within CFA, which Josh laid out well, and how often they show up in court, I have an article that touches on that very issue in the University of Pennsylvania Law Review. I would also add, and this is not DOJ's purview, the CFA applies a little differently for civil claims in comparison to criminal prosecutions. There are some additional elements that can come up in civil claims where a plaintiff does have to show, without getting into the statutory weeds, something like a harm that DOJ, if they were prosecuting for the same conduct, might not have to show. Again, don't want to get too far in the weeds there, and I would encourage you to look at the Penn article if you're interested. Okay. Next question from Kart Kandula. He asks, does CCIPS involve itself in matters of government hacking, which I take to mean NITs, network investigative techniques, and similar methods by which prosecutors might, or folks at FBI might obtain a warrant to search a person's computer in a way where if a criminal were to do it, that might be considered hacking. Now, just to be clear, there are all sorts of things the government can do with a warrant, right? The government can break down your door with a search warrant. If that weren't the government, that would be, breaking and entering. The fact that it would be considered hacking if it weren't the government, I don't think is determinative here. I just wanted to, note that because the terminology can be kind of loaded. At any rate, could you describe CCIP's role, if any, in those types of investigative techniques?
So as I said, we tend to work with agents starting the beginning of an investigation. And they're often going to be asking the lawyer before they want to do some type of investigative step about whether it's legal or whether they need a warrant to get it. And so if they were to propose something along those lines where you're accessing someone's computer without authorization to do this or that, that's absolutely a legal issue we're going to consider. I don't want to give you impression that that sort of thing is happening all the time, but if you're interested in whether CCIPS would be involved in that, we would. I agree, by the way, that government hacking, in fact, when you first said that, I thought you were asking about whether we would prosecute people who hack the government. Yes, we would. But to me, the problem with that is that you're assuming that by calling it hacking, that it ought not to occur. But as Jonathan said, like if you have the correct authorization from law or from a court, then it's lawful at that point, right? So you don't, we refer to, you don't refer to an arrest as a mugging, right? Or as, a drop and tackle. It's not a warrant to mug someone, it's a warrant to arrest someone. You don't refer to a search of a house as a burglary when it's authorized by a warrant. So for that reason, I think on our side, we kind of find the phrase government hacking a little bit confusing and diverting.
If you'd like to learn more, check out my Yale Law Journal article entitled Government Hacking.
Is this just promotion for your CV or?
No, it's not. I claim no credit for these questions. I had no role in them. Okay. Next up from our fearless leader, Matt Salganik. Just a moment, Matt, and let me bring you online here.
Sure. Hi, thank you for a really interesting talk. My question is, are there things that you're seeing out in the world that you think aren't being, that would be interesting and important projects for researchers, academic researchers, that you think academic researchers don't know enough about or aren't spending enough time working on?
Yes, lots. First of all, one of the reasons that I like at every opportunity to talk about cases like the Ryan Lynn case is that I think, in my opinion, I don't see nearly enough discussion of the category of crime that we call cyber crimes against individuals. And it's very often, it's very often targeted at women. It's very often completely disruptive to lives. And it's frankly tough to catch and find and do these cases. I think there's a whole lot more that could be investigated and studied about that. I think also there's the toughest issues I try to write about in my own articles, but I think that there's, we are taking statutes that were written in the 1970s and 80s, updated very lightly, and then trying to apply it to completely modern technologies. And that's a problem not only when you're trying to characterize something as a crime or not, but just trying to figure out what the law asks of government investigators, okay? So part of the role of a government lawyer is to make sure that is to give advice to government executives about how they can follow the law. And with criminal law, of course, the big incentive is you have suppression remedies. If you don't follow the Fourth Amendment, you might have the evidence suppressed and so on. There's a million other different rules, though, that don't necessarily come with them suppression remedies. And these could, you could have people debating in a conference room for hours what the significance of 4 sort of throwaway words in the middle of a statute that Congress wrote in 1986 mean. So I think I would love to see probably more academic interest, sort of not so much in what is the government able to do under the statute or when is there a suppression remedy, but that larger field of stuff that's just sort of trying to answer the legal questions that government lawyers are dealing with more often, which is just plain what's required of us. What does the law want us to do, irrespective of whether there's consequences for not following those rules?
Could you give an example of that? And I appreciate, of course, the usual disclaimers. You're not stating an authoritative interpretation of law or something like that.
All right. So part of the 1986 Electronic Communications Privacy Act was a section called the Pen, Register, and Trap and Trace Act. So the Pen Trap Act you can think of as like a lesser cousin of the Wiretap Act, in that it doesn't let you get the content of someone's communications, but it's the metadata, dialing, routing, addressing, and signaling information, who you're contacting, and so on. Part of the way that was written seems to be extraordinarily broad. So there's actually a criminal component to the Pen Trap Act. It makes it a crime to use a pen trap device without a court order. And that's a crime that actually applies not just to government people, but anyone in the United States. Criminal jurisdiction is not allowed to use, not allowed to use this. That actually became a huge problem when telephone companies started rolling out caller ID in the late 80s and the mid 1990s, because people were making quite serious arguments that caller ID boxes were capturing dialing information, that they were therefore trap and trace devices, and that you couldn't use them. So that actually became this epic battle. That went up to like multiple state Supreme Courts. The FCC had to do a thing. Spoiler alert, no one currently thinks caller ID is illegal, but it's actually really hard to get a clear, coherent view of the Pen Trap Act that both tells us that, both lets us arrive at the conclusions we want to arrive to, that caller ID is lawful, but doesn't also, for example, make all Wi-Fi illegal, because Wi-Fi is also capturing, dialing, routing, addressing, and signaling information, and so on. So that's one of the issues. I sort of laid out a law review article. The thing is, other than that criminal prohibition in there, there's no other teeth to the Pen Trap Act, okay? It doesn't say that evidence gets thrown out if you violate the Pen Trap Act, and you can't sue someone for violating the Pen Trap Act. It's only if the government finds a violation they can prosecute. But as far as anyone knows, the government has never prosecuted under the Pen Trap Act. Nonetheless, when we're advising investigators, cybersecurity professionals in the government, we don't want to advise them to do something that would be a misdemeanor under federal law. So we have to know everything about how that means. When you look at law review, or like when I started looking for law review articles about this, though, the only things I saw people writing about with the Pen Trap Act was what sorts of orders could the government get under the Pen Trap Act, which is a big, complicated, really fascinating question. But there wasn't as much academic interest in what does the Pen Trap Act mean for how the government needs to function. So if I'm giving advice, I would say look for issues along those lines.
So one of the distinguishing features of Princeton, for good or ill, is we don't have a law school, notwithstanding the Princeton Law School banner hanging in my empty office. And so in comparison to some other institutions, I think we're less equipped to address statutory interpretation issues, for example. Not that we can't do it, but it's something we tend to do less of. In comparison, one of the areas where the areas where we tend to be stronger are computer science methods, sociology methods, math sociologists, these sort of kind of more traditional engineering and social science and liberal arts disciplines. Can you think of directions that might draw on the strengths of those areas that might be helpful in addressing computer crime matters? And I don't mean to stump you. If there's nothing that comes to mind, no need to be put on the spot.
I can think of things we need. I'm just not sure these are original ideas on my part. I mean, I think, as I mentioned, we benefit a lot from people who are actually going out and trying to figure out the tactics and techniques of how crimes are being committed, trying to spot, if you will, the choke points, like what are the main infrastructure that a lot of different types of criminals are occurring, being able to map all of that out. An enormous amount of that part, I mean, some of that is sort of traditional criminology disciplines, but a huge part of that is engineering and computer science related. It's basically, I'm not going to say, like, certainly there are a lot of people with CS backgrounds who are looking at how to prevent hacking and so on. I think a lot of them, though, are focusing on the needs of larger enterprises and how you defend a large enterprise with a lot of resources. A much harder problem, I think, is what are you doing for individual small users with low levels of sophistication, but often very high needs for protection. That's best I could do. But
I appreciate it. Okay. Let's see. The next question we've got in our queue is from Heather Menzel, who asks, lately several hospitals have been victims of ransomware. Is there something they can do other than paying the ransom?
So it's a difficult question when you start the timeline after someone's already been hit with a ransom. The best thing you could do at that point is hope that you have a backup or some other way to restore your IT systems so that you can continue funding to do that business. No one in the government is going to tell you it's a good idea to pay the ransom. It's not. You're funding the next attack on the next person. You don't necessarily know who you're paying. It could be, you could be paying, I don't know, North Koreans or someone with sanctions against them. It's just a really bad idea to pay ransoms. I think what we need to do is get the message out more clearly, the steps you should be doing to protect yourselves from this in the first place, which is, correct enterprise IT security practices, patch to the extent you can, and also have backups available if you can. But paying ransoms is just a bad idea.
All right. Our next question comes from Ross Teixeira. Ross, let me see if I can get you online here.
Hello.
Hello.
Hey, thanks. So my question is, I'm aware of laws that allow for easier passive surveillance of foreign citizens compared to US citizens. And so I'm wondering, does that actually result in more finding and prosecution of hacking done by foreign citizens, either within the US or of US citizens, because of laws that allow easier surveillance compared to the overall amount of hacking activity in the country?
Easier surveillance of foreign citizens. I'm trying to piece through. So, the Fourth Amendment is protecting anyone who's within our borders, regardless of whether they're a US citizen or not. Which ones are you talking about? I'm sorry.
I'm familiar. I'm not exactly familiar with which, but I believe I've heard at least of programs that are designed to monitor foreign communication and foreign intelligence. I'm wondering if that translates over to the hacking realm.
It's not as big of an issue as you would think. I think what the intelligence agencies are doing and why they're doing it really does not have a whole lot of interplay with the evidence that we use or collect for criminal investigations. We're separate.
I think well, Josh, I'll leave it to you whether you can agree with this statement or not, but I would say, without going into details, in my experience serving in government, there's an awful lot of attention attracted to foreign intelligence matters, but the linkage between FISA and related intelligence matters and law enforcement matters, at least in the computer crime context, might not be so great as Hacker News and Slashdot might lead you to believe. Look, I won't go further than that. Okay, next question we have is from Rushi Shah. So let me see if I can get this started up. And Josh, for your awareness, Rushi is one of our PhD students who will be starting in parallel to his computer science PhD, a JD at Harvard Law School next year.
Okay.
Hey, can you guys hear me?
Yes.
Great. Thanks for the introduction, Jonathan. So I guess my question is that putting hackers in prison, like you described, for a handful of years feels like a pretty blunt tool for addressing the complicated criminal network that you described in the beginning of the talk that enabled the harm ultimately. Has CCIPS considered any alternative interventions for kind of interrupting this cycle?
Well, I should emphasize, we don't only, when we catch people, put them into prison. You try to get them to cooperate and to reveal as much information about the rest of the network as you can. And then in exchange for that cooperation, we would agree to ask the judge to give him a lesser sentence. And that's a fundamental tool, not just of how computer crime is investigated and prosecuted, but all different types. I think as far as whether there are alternatives, we are, I think we're always conscious of that. You're always wondering whether prison's going to be an appropriate sentence. We aren't obviously paid or incentivized based on how long people end up getting sent to prison, right? We're interested in that justice being done. And actually, that's what federal law requires. It doesn't always say that a judge needs to sentence and so on. But at the same time, we're working under laws that Congress has passed. And Congress very often has said, this type of conduct is severe enough that there needs to be a criminal penalty attached to it. And that's a policy that we're going to implement as we're seeking these sentences as well. I don't know if that answers your questions, but are there particular diversions or other types of approaches that you had in mind that I might be able to talk about?
Yeah, I think that's ultimately what I've just been trying to work through myself, is trying to figure out what those interventions might be. So I guess that's just a topic of research that I'm looking forward to thinking about, because I think ultimately prison might not really rehabilitate. It might not really lead to any of the kind of downstream impacts that we're looking for ultimately. But yeah, I think that was a pretty helpful question, pretty helpful answer to my question. Thank you so much.
Sure.
In the remaining time we have, Josh, you touched on the role of DOJ as aligned with other components of the federal government. And at the risk of an overbroad generalization, I think it might be fair to say that DOJ has long been a player in computer crime and intellectual property matters for the federal government. Some other agencies have been building up their capacity more over time. Could you say a bit about how you think about DOJ's role with the tools it has available to it in comparison to the role of other agencies that have gotten more advanced in this area and have other tools available to them? And I think this might in part answer Rushi's question about how different components of the government bring different tools and perspectives to bear.
It's a good question. So I think if you generalize about the other guys, so there's Department of Homeland Security has definitely really started stepping up its capabilities over the last 7 to 8 years. If you talk to them, they tend to define, well, DHS has several parts. I mean, there are literally criminal law enforcement agencies within DHS, like Secret Service, that we work with the whole time. But they eventually moved things around and created an agency that's now called CISA, Cybersecurity Information. Damn, I forgot their acronym. Someone else will know, CISA. But they have made a pretty good specialization for themselves in basically helping enterprises become more secure. They do quite a bit just getting the federal government to make its own stuff more secure, and God knows there's a lot more work that can be done there. But also, I think they had a notable and pretty correctly lauded effort to try to help state and local governments improve the security around election systems. So that's different from us, right? We are really happy to help out with that mission. We see stuff in our investigations that's helpful to people doing all that. We want to share that as important. We want to help people know what's out there. FBI does a lot of interplay directly with people who need defending and so on, and they do a great job there. But I think as far as our chief line of work, which is investigating, enforcing criminal law, that's a slightly different mission, and we're not, we don't have the budget that DHS has for that mission. I think another big player in the federal government now is Department of Defense. So just purely as part of their military warfighting mission, they've always had a certain amount of need both for computer offensive and defensive computer security. And I've been seeing them grow that capacity more and more. I think I think that's about as much as I'd say about them, but they're there too.
In a very brief final moment, could you maybe say a bit about the Federal Trade Commission, which has also, of course, been trying to grow its capacity in this area? They're an independent agency, of course. They kind of do their own thing. But could you say how you think about the interaction between them and CCIPS?
Yeah, well, let me say not about the Federal Trade Commission, but like it, there is a huge number of sector-specific agencies. So that's a legal term. If, like a bank or a number of different industries have their own regulators within the government. Okay, so you have energy companies would be regulated by the Department of Energy and so on. The FTC is sort of set up as kind of a quasi sector specific agency for a non-specific sector, sort of dealing with, companies and whether companies are frankly being fair and competing with each other by being dishonest to consumers. So they've been doing some really interesting work in suing companies and using their authorities to go after companies that are making basically false promises about the amount of cybersecurity they're offering their customers. They promise that their cybersecurity is just top notch, but then after a data breach occurs, it turns out that they had actually quite poor security and customers weren't getting what they were paid for in that sense. And they'll bring that authority to bear as well. I think that's another really interesting aspect of it. There's also, you didn't ask, but I think there's also the Securities and Exchange Commission has been doing interesting stuff in that, because public companies are supposed to disclose to their investors the risks involved in their business. And if it turns out that you had this catastrophic cybersecurity vulnerability and you weren't doing anything about it, investors would have liked to know about that. So the SEC is increasingly coming to see that as a securities law issue as well. And they've been stepping up their capacity as well. Someone asked about hospitals and so on. Hospitals have, I think their chief regulator is Health and Human Services. So we talk with them too. I know that they're staffing up as well. Basically, almost every part of the government needs to build up this expertise. There's demand across the government for how to approach and try to fix this problem.
Thank you, Josh. I know there are more questions to go. I'm afraid we've hit the end of our time. I want to really thank you for not just joining us, being so candid about the federal government's use of prosecutorial tools in this area, how CCIPS aligns with other parts of the government, the many other subjects we touched on. I have confidence this was tremendously valuable for the CITP community. So folks, I know it's a little limited, but if we could do whatever the virtual equivalent of a round of applause is, I'd appreciate that. And thanks again, Josh. Really appreciate you joining us.
You're welcome. Thanks for the invitation. Goodbye.
So long.